under the if I have to talk about the procedure as to how lawmaking happens, if it is, let us suppose a money bill or anything like that, we all know money bills are always introduced to the Lok Sabha. It will never go to the Rajya Sabha first. Okay. So, but if it is not a money bill, it will go to the Rajya Sabha first, then the Lok Sabha, and then it will go to the president for assent. So here you have to know that there are two things. One is a simple majority way and special majority way. In simple majority, it's like 50% of the houses should agree for it. Okay. And in special majority, what should happen is two-thirds of members of the house should agree for the bill. Okay. Then only it will be passed in the particular house. So if we take Lok Sabha today into consideration, it should have 545 people in it. So two-thirds of them, that much of people should agree for the bill. Then only the bill can be passed. Okay. If it is a money bill, that is the level of rigidity that the law goes through. Okay. But if it is something which is not a money bill, simple thing, that will go through something called as simple majority rule. Okay. Next, we'll talk about the subordinate legislation. Okay, what is exactly subordinate? See, we have the Indian Constitution. From them, other laws have originated. Okay, so what are the subordinate legislation? Under that, it will be the colonial legislation. Okay, IPC is a colonial legislation. We know it was something which the British introduced. So when BNS actually came into existence, they also spoke that we have to come out of the clutches of the British Empire or whatever the British actually did in India. Okay, that was the reason behind why we came up with BNS as a country. Okay, and then we have the executive legislation. See, the legislation can be today made by all the three organs of the government. See, we on one side we say that we have separation of powers in the country, but each organ has got its own way in which it is going forward with making legislations. Okay, even the executive will make legislations during the emergency. I have told you, no, the president can issue ordinance, right? Correct. And then judiciary. Judiciary has also got rule making powers. See, under any act if you take, see, judiciary will have got rule making powers, and then it can. I told you, know, the other day I was discussing about Vishaka guidelines. See, Vishaka guidelines when it originated, it was not something which the parliament did. It was the judiciary which came out and stated that okay, the society, that is especially the women, are vulnerable and they are prone to sexual harassment in workplace, and that is why we need guidelines to assist the court in, coming up with a remedy for such victims. Okay, that is why the judiciary came up with the Vishaka guidelines. Okay, and then we have legislation under local self-government. See, here you have to understand that I have told we have division of power. Okay, division of power between center and state. So how will the state implement division of power? It will give power to each department. Okay, that is the way in which the power has got decentralized to the maximum extent. Okay, I had told you the earlier class that power is an abstract notion. So we have separation of functions rather than separation of powers. Okay, so all the functions of each department has got decentralized to the maximum extent. So that is why today we can see that even the local self government can make legislations. For example, if it wants to impose water tax or property tax, it will have to follow the parent act, and also it can come up with its own rules and its own way in which calculation of property tax happens. Okay, so that power has been given to local self government. If you look into everything, see, laws, we know the definition of law. Law includes order, bylaws, ordinance, and rules, regulations, and all these things. These are all which come under delegated legislation. See, act is something which is a primary legislation. Under them, if there are rules and other things, they are delegated legislations. Okay. Then we have autonomous legislation. For example, we have this college. So, for the functioning of the college, the management can do certain rules and regulations. For example, if let us suppose that one of these students he is behaving too harshly to towards the teachers. And he is also somebody who harasses women, and he does all these things. So to make sure that the student is actually reformed and all these things, the college will come up with a disciplinary committee. The disciplinary committee will evaluate his level of understanding, the background behind which he comes from, and all these things will be evaluated, and then a disciplinary action will be taken. For that to happen, the college will come up with its own procedures. So those procedures will come under autonomous legislation. Okay. For example, if the college wants to conduct any exam, so what is the way in which it has to conduct the exam? It should, all the rules regarding examination and all these things, it should be in consonance with the UGC. Okay, UGC. Okay, whatever the UGC says, that should be followed under the rules, bylaws, and all these things. Okay. See, the autonomous legislations cannot go ultra minus the intentions of the UGC. Okay. And then we have the delegated legislation. See, what is something which is delegated? Let us suppose, see, your Anjana, no? So Anjana, let us suppose, was given work to go forward and become a president of the college. Okay. So what Anjana will do, she cannot do all the works. So that is why she will say, let the committee or whichever is heading the institution, let the committee of students have a separate. Okay. Let the committee have a student convener. Okay. Let it also have class representation. Okay. All these things will be something which Anjana will suggest. So now what will happen is uh, uh, that is nothing but delegation of powers. She is delegating her functions. See, since Anjana cannot do everything on her own, she will delegate it to the concerned department or concerned, position. Okay. Now we will talk about equity. We discussed about equity, right? It is a common law principle. So when should equity be invoked? When monetary compensation is not enough. That is when equity will come into existence. And then equity does not destroy the law nor creates it but assists it. Okay, that is what equity does. Okay, it will not destroy the law, it will not create the law, but it will only assist the person. See, if I have to talk about equity, let us suppose see, we all know there is a limitation act. Okay, so for each and every suits in India, civil suits in India, we have the various laws related to limitation. Okay, for example, if it is a money recovery suit, the limitation period is 3 years. So beyond 3 years, one can not go forward and ask for relief. But see, if there is a delay of 6 months or 1 year, it can be condoned. But what happens if a person doesn't recover the money even after 10 years? So the Limitation Act or the civil law will not come to his rescue. It will be the equity law and the common law which will come to his rescue. Okay, he has see, there is something called as doctrine of acquiescence. Acquiescence means delay. If there is delay in you asking for a remedy, only the common law can come to your rescue, not the other laws. Okay. So equity is focused on what ought to be done. Okay, ought to be done. And I told you, doctrine of acquiescence. So the law will come to a rescue of person only if he is time bound. Okay, and if he follows the limitation period. Okay. See, even if we invoke the principle of equity after like 10 years, the court should grant him the remedy. See, let us suppose that the person who wanted to seek, a money recovery, he was bedridden. Okay, that is why he was bedridden for 10 years, so he could not seek the relief at an appropriate time. So the court will consider that, and the court will let him go forward and argue his matter, and get the money recovered. Okay. And then there is also a principle called as
Clean
clean
hands.
hands. If a person wants to approach the court for some remedy, he has to approach with clean hands. For example, like I told you, you and your friend have a house, okay, next to each other, and then let us suppose the one of your friend is constructing a wall there. Okay, okay. So to stop her from doing it, you will go and use violence, and then you will seek an injunction. So you are not approaching the court with clean hands. So will the remedy be granted? That is the point. Okay. See, you cannot achieve anything through violence in the court of law. See, if you operate anything, if you achieve any goal through violence, the court will definitely frown. It will not grant you the required relief. Okay. You can always debate about it. Okay. We can always debate about it. We can do it in the next class.
Okay.
And then we have the international law. Under international law, we have the public international law and private international law. Please make a note of it. Okay, public international law is concerned with the relationship between the various legal entities. For example, we have the states and then we have the international organizations. So, public international law will talk about the relationship between all these entities. Okay. So under the international law, we learn all these things. What are states and what are international organizations? And then we'll also talk about, see, under the public international law, we have the various theories, okay, theories, and then we have various principles, and it will also talk about the immunities, okay, if there is an ambassador, that person, what are the immunities that the ambassador has got, or a diplomat has got, and all these things are dealt under the public international law. So under public international law, we'll talk about the UNO, we'll talk about the
CGA.
ICJ, that is the International Court of Justice. All these bodies will come under the public international law only if it is concerned with the state and its relationship with the other states. But if the matter is related to an individual in that state and it is affecting only his individual rights, that will come under private international. Okay. So private international law, what will it talk about? Private individuals in international context. Okay, that rules and regulations that operate only for that individual, but in an international context. That is when private international law will come into existence. Okay. So private international law, if I have to give you example, we have the arbitration. Okay. See, whatever is the international commercial agreements that are happening, they settle the disputes using arbitration. So, if at all, let us suppose, sometimes what will happen is in the various commercial contracts, they will choose the court which will get the jurisdiction. For example, if the matter is between Yugoslavia and India, the Yugoslavian party will say, let the matter be tried before our court. And India will say, let the matter be decided before the Paris court. Okay? Paris court, because that is where the operation is actually happening. So that is the way in which they decide the court of jurisdiction. So if there are issues related to that, that will come under private international law. Okay, it is affecting the individuals, not the state in particular, but the individual. Okay, and then we have the cross-border transactions. See, there are mergers and acquisitions which happen. Okay, mergers and acquisition. Okay, what is exactly mergers and acquisition? See, let us suppose there are two companies, A and B. They are they are doing something like noodles business. So what will happen in a merger is that company A, let us suppose it was going through something called as corporate debt restructuring. Okay. So one of the strategies that was suggested to it was to go forward and merge with company B. So that is why it will go and join hands with the company A and B, and then they will come up with a company which will operate. Okay, so they are merging together. Okay, and in acquisition, what will happen is, see, there will always be a parent company which will acquire a subsidiary company. Okay, so in acquisition, a larger company is acquiring the smaller company. Okay, but in a merger, it is always the companies which operate at the same level. They are the ones who will merge together. Okay. So the cross-border transactions such as mergers and acquisitions, those are also something which will come under private international law. Okay. Here also, like I told you, I had given you an illustration. You are going on a ship Okay, that will reach the international borders that to
Sri
Sri
Lanka.
Lanka. So there, let us suppose you end up in a duel and kill a person. So should your country's domestic law come to your rescue, or should Sri Lanka's law come to your rescue?
Our
So that is
country.
the point. You will be tried under the Indian law because you are an Indian citizen, and the act has happened on an Indian ship. Okay, so that will decide the court which will get the jurisdiction. Okay, law of the state. Okay, here there are two branches: constitutional law and administrative law. Okay, so constitutional law is also a branch of public law. I had discussed earlier, right? So it is a branch of public law. So it will talk about the powers and functions of legislature, executive, judiciary. It will talk about the basic structure of Indian constitution. It will talk about fundamental rights. It will talk about fundamental duties. Then it will talk about the directive principles of state policy, and all these things are there. Okay. So constitutional law will discuss that. Okay. Next we have administrative law. Even under the constitutional law, if there are any laws being enacted, they should always be in consonance with the Indian constitution. Okay, if the laws are not enacted that way, then the laws can be struck down as unconstitutional by the Supreme Court. Let us suppose we have okay triple talaq. Okay, triple talaq. The court stated that triple talaq was not an essential religious practice and that was struck down as unconstitutional. So the court got that power to do it. Okay, they went into a lot of